This is interesting. In 1999, I believe, Ron Motley made a statement. Now, he had just collected a lot of money from tobacco litigation. And he made a statement. The statement was, I'm going to spend a lot of this money on lead paint litigation. And if I don't have the paint industry on their knees by 2003, I'll give them my boat. Now that boat, now this is a quote from the Dallas Morning News, I didn't make this up. That boat is actually a 127-foot yacht, I'm told. I've not seen it, and I don't know anything about yachts because I'm not in that financial range. But all I want to do, and I know Fidelma works with Mr. Motley, but if there's anybody out there, where's the boat? Because I'd like to have that boat. I'd like to sell it and defray some of the cost of this litigation we've been involved in. The lawsuit was filed by the state of Rhode Island. And that lawsuit was filed against 5 corporate defendants. And it alleged that they were involved in a public nuisance. And the public nuisance was lead pigment in paint on homes in Rhode Island. That was, I think, 8 years ago. First trial ended in a mistrial with 4 of the 6 jurors voting for the defendants. So it was tried again, and there was a verdict rendered. And I'll be giving you some background on it as we go, but that verdict was rendered against the defendants. So here we are. I saw a magazine the other day. There's this neat thing going on where they give you numbers. I don't know if you've seen it, you know, like 10, which means something, and 11 means something else. So I thought I would do that. Now this may fall flat. If it does, please don't hold that against my client, you know. But I'm going to try this. Let's do lead paint by the numbers. 169. That's the number of rental properties. And this information comes from the Department of Health, State of Rhode Island. Number of rental properties that received a second notice of violation. This is current now. To correct lead hazards in the property. 91. It's the number of Rhode Island properties currently identified as the source of multiple lead poisoning. Now, lead poisoning amongst people is defined as 10 micrograms per deciliter. I always turn those around because the reason I'm a lawyer is I couldn't make it through chemistry. But 10 micrograms per deciliter of blood. Okay? Now, there are 91 homes or places in Rhode Island that are currently identified where there have been more than one instance of that happening. 36. And this is a truly outrageous number because this number hasn't changed in 7 years. 36 properties have been declared unsafe for human habitation by the state of Rhode Island's Department of Public Health. Now, if I were the Attorney General and had been the Attorney General for the state of Rhode Island for 9 years, you know, whether or not corporations are responsible, I ought to stop that. You know exactly how to reach those people. I can go on Google and find out. In fact, I've done it. There's an address, and there's an owner, and there's an address for the owner. You can find these people and you can make them do something about that if your primary motivation is protecting children. 0. Well, that's the number of these property owners that the Rhode Island trial court allowed my client and the other defendants to add into this lawsuit. Because if the Rhode Island Attorney General isn't going to do it, working through his contingency fee counsel, then we would do it. But no, the Attorney General filed a motion to sever and stay that proceeding. So those people with that record and those kids being poisoned just keep on for 7 years. That's what the Attorney General, through his contingency fee counsel, did. 320, big number. For 15 years, all 15 years, that's the total, a little less than 30 a year, referrals by the Department of Health to the Attorney General of Rhode Island for prosecution under law in Rhode Island. That is the law that says you can't do that if you're a landowner, if you're a property owner, if you're a landlord, if you're a slumlord. You can't do that. That's against the law. 320 referrals in 15 years. Now, 240,000, that's a number we can all relate to. That's the total number of housing units that the Contingency Fee Council, representing the Attorney General, says that my client and others have to abate in 3 years. 240,000. That's virtually every dwelling in Rhode Island that's older than 1978. Now, this is an interesting fact. Rhode Island's own statistics point out that 10 to 20% of the children in that state have elevated blood levels from the public water system. The state itself is putting lead into the children. 20%. Give me the benefit of the doubt. Take the higher number. 20%. 60 plus. That's a good one. You all are going to relate to this, folks. The number of years that cars and trucks have used gasoline with tetraethyl lead in it. You and I, when we were growing up, knew it as leaded gasoline. There wasn't any other kind. It was an additive. Everybody put lead in gasoline, and it got put out the back end of the truly uniquely American concept of an automobile, lots of them, driving all the time. And I'm telling you, look at the numbers, 250,000 tons of lead were released into this environment in this country alone. Where did it go? It's not in the paint. Where did it go? It's in the dirt, it's on the houses, it's in the schoolyards, it's everywhere. You know, I'm just a dumb kid from Kansas. I can go out in the middle of a wheat field, and you can find a blood lead level in kids in western Kansas at 2. You can go to Kathmandu in the Himalayas, and you can find the blood lead level of 2. Lead is ubiquitous, folks. It's everywhere. Now, this is an aside. If you want to sue somebody who's putting lead in paint, I can give you 2 right now, and they haven't been sued. Mattel and China. Knock yourself out. They are putting lead in paint, because in a minute you're going to find out who's not and who hasn't been. 0. The number of enforcement actions or abatement proceedings commenced by the Attorney General acting through Contingency Fee Council against water suppliers, including the Rhode Island government itself, manufacturers of tetraethyl lead, and manufacturers of the products that use tetraethyl lead. That means cars. 0. We're not interested in that, I guess. 21. Well, this requires a little explanation. You're probably saying, what are you doing standing up here ranting and raving? Well, I'm trying not to rant and rave, but what am I doing here? Well, I represent a client that acquired a company called Millennium Holdings that 21 years ago held stock in a paint company. You've probably heard of it, Glidden Paint. We held the stock. 6, it's the total number of months that Millennium Holding held that stock 21 years ago, 6 months. Now, this is an interesting fact. 28. the number of years prior to Millennium Holdings stock ownership that Glidden discontinued using lead paint. So folks, we haven't been using lead paint. We haven't been putting lead in paint in this country for 50 years. And my client's responsibility is goose egg, because we held the stock of a company for 6 months that had not put lead in paint for 28 years prior to that. 50 years ago, when the government, federal and state, required that you put lead in paint as part of the specifications if you're going to do work for them, 50 years ago, this was going on. My company wasn't involved in it in the least. No witnesses around, nobody here to dig it out, do anything at all about it, and yet here we sit, having been sued for 7 years. The state of Rhode Island set a standard. It said we're going to have elimination of lead poisoning. That's terrific. That's what they should be doing. And they said it's 5%, and you can see the definition. And they needed to do that by 2010. They said if we do that, that'll be really good. Now, the trial that I talked to you about, the second one, that occurred in 2004, 2005, early 2005. Now, when the report came out, it came out showing that they had met their elimination goal. So lead poisoning had, by their definition, been eliminated. It came out during the trial. What's interesting is the contingency fee. Wow, that's hard to say, Henry. I'm going to need something to drink here. The contingency fee counsel representing the Attorney General in the state of Rhode Island argued to the jury, we're at a plateau. We can't get that rate. We can't get down to our goal. We can't do it. We're going to need your help. You're going to have to find these guys liable. Well, that's interesting, because they didn't tell the jury what happened during the trial. They didn't tell me. They didn't tell one of the defendants. They didn't tell the judge. So the jury was prejudiced by a false statement that their rates weren't going down. In fact, they knew they were. 520. That's the total number of new cases under that standard in 2006 they could have and still be meeting their goal. So how many have they had in 2006? 500. So they are continuing down below the 5%. However, they changed the standard. Well, there you go. But what happened to the idea that if that's the standard and you met it, imposing a new standard or a new set of rules or changing the rules on a set of defendants? 50 to 60 million. That's the amount that Rhode Island spent to actually achieve its elimination goal 4 years earlier than they had said they would. 2.4 billion. Now, let me bring you up to date on the case. We have an appeal filed. We're going to appeal a number of things, some of which I'm going to tell you about, but we're going to appeal that, and we hope that we're going to win on that appeal. But in the meantime, at the urging of the Contingency Fee Counsel for the Attorney General, the judge has bifurcated the process and said, well, we're going to work on an abatement plan while you're appealing, because I think you're going to lose, and I want to have this abatement plan all ready to rock and roll, and here's the way we're going to do it. We've got all kinds of things we have to talk about. First, Attorney General, you give us a plan, and then you defendants, you give us a plan so many days later. Well, they recently announced their plan. 2.4 billion is all they need. 2.4 billion is what they need, and that's based on the 240,000 dwellings times some factor to eliminate lead completely, assuming that it's there, assuming that these parties are responsible. 2.4 billion, 10,000 new jobs, the largest public works program ever in the state of Rhode Island. That's pretty neat. Now, here's what's interesting. 16 2/3% is the contingency fee specified in the agreement between the Motley Rice firm and the Rhode Island Attorney General. Well, that's $399 million. That's a lot of motivation. 0. Well, you heard me say it earlier, I'll say it again. This has never been, make no mistake, it's never been about children. Because it's not been one child that's been helped by 7 years of litigation of this sort. It's abusive. It's overreaching. I heard some discussion earlier, people concerned about how do you deal with corporations that are misconducting. I heard discussions about, corporations are out trying to get tort reform and that's really a bad thing. I can give you a standard if you're looking for one, folks. I know that there are a lot of folks out there that have to look for standards because sometimes you don't give it. Here's the standard. Is somebody abusing the process? Because if they are, that's probably an indication that that party should lose. And I would submit to you that the reason why most corporations are frustrated with what's going on in the U.S. has to do with abusive, predatory litigation ideas created by the contingency fee bar. You know, there are only 2 legitimate American art forms, jazz and contingency fee counsels. Nobody else uses contingency fee, just us. Now, jazz is a lot of fun to listen to, excuse me. It's a lot of fun to work on, but it's a lot of fun to listen to. The other one's not. Now, folks, the problem we've got is abuse. Abuse of process, abuse of system. There are always good ideas behind why laws say what they say and what we try to do. But when they are abused, when they get taken too far, when you get off course, when you forget about children and start pursuing $399 million, then you've got abuse. And that's got to stop. $1 million. Now, DuPont was a defendant, but not anymore. They said it's not a settlement, we just quit, and the other side let us quit. Well, I don't know, but they agreed to pay $12.5 million. It's kind of interesting how they agreed to do it. $1 million, the Attorney General said, well, you need to give that to my alma mater. That would be Brown University. $2.5 million, well, that $2.5 million goes to a Boston hospital. It doesn't have a lead program, and not, you know, it doesn't deal with lead at all. And it's not in Rhode Island. But it's interesting. It does have a pretty substantial mesothelioma. Now, that's asbestos litigation, folks. It does have an active mesothelioma program, which the Motley Rice firm had made a commitment there would be a contribution to. Now, I'm not making this up, folks. It's in the public record. You can go and dig it out yourself. $9 million. Well, the rest of that goes to an organization, again, not in Rhode Island. Now, I don't know where the authority comes for an attorney general or his contingency fee counsel to let money run across the border of the state. That'll be a good question when somebody's going to ask it one of these days. This is going to Washington, D.C. for a fund that a DuPont lawyer runs. That's pretty interesting. Well, here it is. Number of Motley Rice partners who currently serve as the treasurer of the Rhode Island Democratic Party. Now, look, I said I'm just a dumb kid from Kansas, but I sat down the other day with a Democratic fundraiser, had dinner with him. He wanted to meet several of us, and so we did. You know what he told me? I guess I should have known this all along. He said, man, the plaintiff's bar, that's the mother's milk of the party right now. We got all this money and everything else. Well, okay, maybe that's what's gone down. 3, the number of times the Attorney General was sanctioned during the trial for making public statements that were designed to or had the effect of influencing the jury. Obviously, it's our view the jury was improperly influenced, therefore a decision. The judge sanctioned the Attorney General 3 times. Now, I'm trying to get at abuse. I want to tell you what I'm seeing right here. When you allow contingency fee counsel and the power of the government to combine, you have a potential for abuse. And there it is, influencing the jury any way necessary. Get it done, $399 million. Folks, that's just dead wrong. It's dead wrong in Kansas, dead wrong everywhere else. I got 1 minute. I'm going to tell you where else it's dead wrong and why I'm asking you as judges, keep all this in mind. New Jersey Supreme Court had the same concept by the same law firm in front of them on behalf of a bunch of governmental agencies. They threw it out entirely. It's not an acceptable theory of public nuisance. And this is what New Jersey Supreme Court said. If we were to allow this theory to proceed, we would create a monster that would in one gulp devour all of products liability law. The Illinois Supreme Court, similar rejection of this public nuisance theory. Missouri, similar rejection of this public nuisance theory. Ohio, the same. California basically said, we have a policy, it's called the Clancy Doctrine, from the case called Clancy, that says contingency fee counsel can't work for the government because it is inconsistent. The government's duty is to be fair and not always win, whereas the contingency fee counsel only gets paid if they win. It's inconsistent. And so they severed it and said, you can have your lawyers, you can pay them hourly, but you can't pay them on a contingency fee. Wisconsin, personal injury cases. I'm going to let Mr. Nyland talk to you about those, but I'll tell you right now, when juries see this for what it is, they reject it. Thank you very much, folks. I think I've gone too long.
Now we have Fidelma Fitzpatrick from Providence, Rhode Island.